Good morning. So the Subcommittee on Capital Markets and GSEs will hereby come to order. Today's hearing is entitled, as you know, the Jobs Act at 4, examining its impact and proposals to further enhance capital formation. And next, without objection, the Chair is authorized to declare a recess of this subcommittee at any time. And also, without objection, members of the Financial Services Committee who are not members of the subcommittee may sit on the dais and participate in today's hearing. I welcome all the members of the on the panel today, and I now recognize myself for 3 minutes for a opening statement. You know, it's not often that Congress can look back at a major piece of legislation and be able to measure the tangible, positive impact of that's having on people's lives and our economy. Too often, we find ourselves, especially in this committee, counting up the cost of the many misguided Washington mandates and comparing them with the so-called phantom benefits promised by the bureaucratic class and the sponsors of those regulations. Fortunately, that's not the case today. The Jumpstart Business Startups, or the Jobs Act, was signed into law literally 4 years ago this month, has by, I think, most measures, been a resounding success for our economy and the future of innovation here in the U.S. The Jobs Act did this not by creating new federal mandates or spending taxpayers' money on wasteful government programs, but instead by empowering entrepreneurs and innovators who were struggling under a regulatory regime that was better suited back for 1934 than it was for 2016. So just consider some of these facts. The Jobs Act has led to the resurgence in the initial public offering, the IPO market, with some 85%, yes, 85% of IPOs since April 2012 coming from emerging growth companies. Second, companies have raised some $50 billion under the new Reg D provisions that allow businesses to solicit an offering to the general public. Third, while the newly modernized Reg A Plus is only a year old, businesses are already beginning to issue securities under that exemption. And finally, recent reports indicate that the SEC has already received up to 30 applications for portals under the new crowdfunding rules, which are set to go into effect next month. So while it's clear that many parts of the Jobs Act are working as intended, the point of the hearing that we're having today is not to say how great we are for doing that and job well done. For starters, because the Senate has tried to back its best, you would say, back in 2012 to neuter some of the provisions, especially in the crowdfunding title, and the SEC has also taken some liberties with other rulemakings, the Jobs Act obviously needs a little bit of fixing. So I want to thank the gentleman from North Carolina, that would be Mr. McHenry, for putting forward the Fix the Crowdfunding Act. And what does it do? It makes some necessary changes to help ensure that Title III reaches its full potential. And additionally, I have put forward a bill. It's called the Private Placement Improvement Act. That will prohibit the SEC from implementing some burdensome new regulations on Reg D issuers that are uncalled for in the Jobs Act. And so we'll also consider 2 other bills today. Mr. Emmer, who is here today with us, has introduced an innovative bill that would create a safe harbor, if you will, for so-called micro offerings. And Mr. McHenry, again, has another bill, which would raise the threshold for when venture capital funds would have to register with the SEC. So finally, in addition to these targeted fixes, I'm also interested in hearing from the witnesses about further areas that Congress should be addressing in order to maintain the competitiveness in our capital markets. For example, we should be exploring the cumulative burden that some with being a public company, including, unfortunately, some of the ridiculous disclosure requirements of Dodd-Frank, as well as the outsized influence that proxy advisor firms have in the corporate government arena. It's also time, finally, to think more about the lack of research and liquidity that exists for some public companies, and whether the equity research global settlement of 2003 swung the pendulum just too far and has led to a dearth of research for small cap funds. So these are all very important questions, and therefore I look forward to this hearing from each one of our witnesses today. And with that, I now yield to the gentlelady from New York for 5 minutes.
Thank you so much for calling this important hearing. I thank all of our panelists for attending, particularly Mr. Beatty and Mr. Griggs, who is from NASDAQ, which is located in the district I'm privileged to represent. I look forward to all of your testimony today. This hearing will examine 4 legislative proposals that are intended to make it easier for companies to raise capital. While I'm interested in hearing our witnesses' thoughts on these proposals, I do have some serious concerns with some of the bills as they are written. H.R. 4850, the Micro Offering Safe Harbor Act, creates 3 entirely new exemptions from the requirement to register securities. First, the securities will be exempt from the registration requirement if the buyer has a, quote, substantive pre-existing relationship, end quote, with an officer of the company before he buys the securities. Second, the securities will be exempt as long as the company, quote, reasonably believes, end quote, that there are no more than 35 buyers who have relied on these new exemptions in the previous year. And finally, the securities will be exempt if the company hasn't sold more than $500,000 of securities in the past year. Based on the title of the bill, I believe that it is intended to apply only to very small offerings of securities, or, quote, micro offerings, as they're so called. However, the way I read the bill, it actually applies to all offerings, no matter how large, as long as the buyer has a substantive pre-existing relationship with an officer of the company before he buys the security. I am concerned that this would blow a hole in the securities law because a substantive pre-existing relationship could even be developed during the company's sales pitch to the investor. It is important to note that we are already seeing a trend toward the use of unregistered private securities rather than publicly registered securities. In fact, the private securities market is now larger than the public securities market. In 2014, companies raised $2.1 trillion through the private securities market compared to only $1.3 trillion through the public securities market. I believe we need to take a step back and think about whether this trend is a good thing. Clearly, this means that more securities are being sold with fewer investor protections. Are investors in these securities being harmed or exposed to risks that they don't fully understand? Or are investors capable of bearing these risks, which they fully understood before they purchased the securities? These are important questions that I think we need to ask 4 years after the Jobs Act. Finally, another bill we will consider today, H.R. 4854, would significantly expand the number of investors who can invest in venture capital funds that are exempt from SEC oversight. Under current law, a fund can be exempt from SEC oversight if it has less than 100 investors and its securities are not offered publicly. A fund with fewer than 100 investors, which is not marketed publicly, poses fewer investor protection concerns than large funds that have lots of retail investors in them. This bill would raise that threshold from 100 investors to 500 investors, but only for venture capital funds. I would like to hear from our witnesses why this change to such a long-standing rule is necessary and what problem are we trying to solve. So I'd like to thank all of our witnesses for being here today, and I look forward to a robust discussion. Thank you so much, and I yield back the balance of my time.
I thank the gentlelady and for her questions that she raises there as well. I now recognize the Vice Chairman of the committee for 2 minutes.
Thank you, Mr. Chairman. I thank you for holding today's hearing. I'm pleased that the subcommittee is continuing its efforts to enhance the strength and vitality of our domestic capital markets. 4 years ago, this committee achieved bipartisan success with the Jobs Act, and I remain hopeful that we can continue to improve upon that work. Capital formation for small companies is critical to the success of our economy, and as I travel across Virginia's 5th congressional district, our district, I'm regularly reminded of how our nation's small businesses and startups are in dire need of capital, how they have trouble accessing capital, and how their potential success is often thwarted by outdated and unnecessary policies imposed here in Washington. While small companies are at the forefront of innovation and job creation, these same companies often incur obstacles in obtaining funding in the capital markets. The Jobs Act sought to remove some of these burdens by recognizing that our securities regulations are often written for larger companies. Today, we have 4 additional legislative proposals that are all seek to expand and improve access to capital for our small businesses and startups. These proposals are aimed at amending the Jobs Act to enhance capital formation for small companies and their investors. Small companies, as we all know, are the backbone of our economy and our nation's most dynamic job creators. We must do everything possible to help them succeed, and if we can do so without compromising investor protection and transparency, then we must embrace these ideas. The ideas we're discussing today are a step in the right direction, and I thank the sponsors for their work on this legislation. I look forward to the testimony of our distinguished witnesses, and thank you for your appearance before our subcommittee today. Mr. Chairman, I thank you, and I yield back the balance of my time.
I thank the gentleman. So we now turn to our panel before us. Some of you have been here before, some have not. You will be recognized for 5 minutes. Your entirety of your written statement, which has been provided, will be made part of the record. In front of you, of course, is your lights or clock. When the yellow light comes up, that gives you a 1-minute warning, so we ask you to try to sum up during that time, and when the red light comes up, that means we're no longer listening. No, it doesn't mean that. But that means that your time is up. So we will begin with Mr. Atkins. Welcome to the panel once again. Good to see you, and you are recognized for 5 minutes.
Good morning. Well, thank you very much, Chairman Garrett, Ranking Member Maloney, and members of the committee for inviting me to testify today. My name is Paul Atkins. I'm CEO of Potomac Global Partners here in Washington, D.C. And for 6 years, ending in 2008, I served as SEC Commissioner. Small businesses are vital to our nation's economy. Startups and young companies are a primary driver of job creation. If we're serious about spurring real economic growth, creating more jobs outside of Washington, D.C., and breaking down our two-tiered economy, we do not need higher taxes or more government spending. Instead, we need more entrepreneurs and small businesses and a sensible regulatory environment in which these individuals and firms can succeed. The Bipartisan Jobs Act proves that you do not need hundreds or thousands of pages of complex legislation to help Main Street businesses and protect consumers and investors. At only 22 pages, the Jobs Act has already achieved significant results for small businesses seeking access to much-needed capital, while at the same time maintaining important investor protections and providing more opportunities for Americans to put their hard-earned dollars to work investing in America's future. Thanks in large part to the IPO on-ramp, 2014 was the best year for IPOs since 2004, with emerging growth companies taking advantage of the on-ramp's scale disclosure and reporting requirements, all of which make public offerings more attractive for smaller companies while preserving essential information for investors. More IPOs generally means more jobs. Thanks to Titles 2 and 4, we're also seeing issuers and investors starting to take advantage of offerings using general solicitation and the amended Reg A+ exemption. Just 4 years after its enactment, the Jobs Act has helped rationalize and modernize the current regulatory environment to better serve small companies and investors alike, but the job is not done. The Obama administration continues to bury small business under a record amount of red tape. I believe that a major cause of the uncertainty still handcuffing our economy is in fact government policy, particularly the sweeping Dodd-Frank Act. The real tragedy behind Dodd-Frank and the hundreds of other major rules flowing from Washington every year is that consumers, investors, and small business are harmed the most. It's no surprise then that major small business surveys recently have highlighted government regulation and access to credit as being among the most significant growth concerns currently facing small companies. The SEC, which has a statutory mandate to facilitate capital formation, has also neglected small business, or worse, firmly placed itself in the way of positive reform. The SEC could have implemented the provisions of the Jobs Act on its own, but instead the agency did neither, burying its head in the sand while Congress went to work. In fact, instead of fulfilling its core mission, the SEC has misprioritized its resources by focusing first on Dodd-Frank rules that do not address the real causes of the financial crisis and only add to the regulatory burden already weighing on our economy. Finally, when faced with a clear Jobs Act mandate to simplify and lift the ban on general solicitation, the SEC chose on its own to slow the pace of reform by issuing an additional rule proposal to amend Reg D in ways that would fundamentally undermine the purpose of the Jobs Act. The proposal would add unnecessary costs and burdens on small issuers and investors seeking to take advantage of general solicitation under 506C, for example, by making issuers submit 2 additional Form D filings, imposing a draconian 1-year ban on using Rule 506 for failing to comply with the Form D filing requirements, even for a foot fault, and 3, forcing issuers to file all general solicitation materials with the SEC. Now, I've talked to lawyers, law professors, and venture capital investors in Silicon Valley and elsewhere, and they advise would-be issuers to shun, not use at all, 506C offerings because of the uncertainty and the potential for gotcha enforcement actions by the SEC and I think by the states as well. Indeed, because the nature of these non-public offerings mean that it's hard to define a beginning and an end to the potential securities offering, the potential for gotcha enforcement actions with these offerings is real and a trap for the unwary. Chairman Garrett's bill, the Private Placement Improvement Act, would go a long way towards allowing issuers to use 506C in the manner Congress intended. Over the last 5.5 years, this committee has been at the forefront of helping America's small businesses grow and create jobs. I thank you for all your efforts and for the opportunity to testify here today. Thank you very much.
And I thank you. Next, Mr. Beatty, welcome, and you are recognized for 5 minutes.
Thank you. Good morning, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. My name is Bill Beatty. For the past 30 years, I have worked as an attorney in the Securities Division of the Washington State Department of Financial Institutions, and since 2010 have served as the Department's Securities Director. I am also a member of the North American Securities Administrators Association, having served as the association's president from 2014 to 2015. Since October of 2015, I have served as chair of NASA's Committee on Small Business Capital Formation. My many years in securities regulation have led me to the inescapable conclusion that successful capital formation must include robust investor protection. I'm honored to testify before the subcommittee today on these 4 legislative proposals. The first bill, the Private Placement Improvement Act, limits the SEC's authority to revise filing requirements for Regulation D. As we know, Title II repealed the long-standing prohibition on general solicitation and advertising under Rule 506. State securities regulators remain deeply concerned about the potential negative impact of these changes on investors. When the SEC adopted these rules to implement Title II in 2013, it also voted to propose rules that would mitigate the risks to ordinary investors from 506 offerings. These included requiring a pre-filing of Form D when issuers intended to advertise, and imposing penalties on issuers who failed to file Form D. Form D is crucial to state securities regulators like me because it is often the only information we can use to determine if an issuer is conducting an offering in compliance with a lawful exemption. By prohibiting the FCC from adopting these common sense investor reforms, the bill would tie the hands of the SEC to implement the few investor protections it has adopted or proposed in connection with Rule 506 and undercut the SEC's most promising efforts to gather data and additional information about the 506 marketplace. NASA is strongly opposed to any action by Congress to diminish the ability of the SEC to address the risks to investors resulting from lifting the ban on general solicitation. Finally, we take issue with the suggestions that filing a Form D is an onerous regulatory or compliance burden. Form D is a short form filed electronically. It captures 8 pages of information and is minimal relative to the information that in the issuer's offering documents. Moving to the Micro Offering Safe Harbor Act, which would amend Section 4 of the Securities Act and also preempt state securities offerings. We are deeply concerned about this bill as well. Notwithstanding the title, the new exemption would not be limited to micro offerings. In fact, it would permit the raising of unlimited amounts of money. The bill would not prohibit general solicitation, disqualify bad actors, limit offering amounts, or even permit notice filings to state or federal regulators. It would not impose a holding period or other restrictions on resale of securities purchased under these new exemptions, making these offerings highly susceptible to price manipulation and pump and dump schemes. The bill would also make the task of policing the unregistered securities marketplace much more difficult for securities regulators. The new exemption established by the bill would likely supplant Rule 506, but without the basic information provided in Form D. Beyond these overarching concerns, each of the new safe harbors is discussed in my written comments. Moving finally to the Fixed Crowdfunding Act, proposing revisions to Title III, state securities regulators understand the theoretical basis for several of the proposed amendments, and we do not necessarily oppose them. We also appreciate Congress's frustration that federal crowdfunding has yet to take effect. It has been 4 years since the passage of the Jobs Act, and during that time, dozens of states have adopted and implemented intrastate crowdfunding exemptions. However, the critical point for Congress today is that there is no answer to the question of how to fix federal crowdfunding because we do not yet know what will work, what won't work, or what the new marketplace will look like. There is no data whatsoever about federal crowdfunding and only limited data about what is working at the state level. By contrast, several years from now, there will be a wealth of data both from state and federal crowdfunding regimes. State securities regulators urge Congress to refrain from amending Title III of Jobs Act at this time. We believe that to enact legislation at this point would be counterproductive and premature. Instead, we urge Congress to closely monitor the implementation of Regulation CF, state crowdfunding exemptions, to conduct oversight and gather information about the new marketplace. With the coming implementation of federal crowdfunding rules and with intrastate crowdfunding already available in the majority of states, we shall very soon learn whether and how these new capital raising tools will be used. Thank you again, Chairman Garrett, Ranking Member Maloney, for the opportunity to testify before the subcommittee today.
I thank you, Mr. Beatty. Next up, Mr. Griggs. Welcome, and you're recognized for 5 minutes. And is your button pushed? I forgot to do that at the very beginning as well.
Well, thank you, Chairman Garrett and Ranking Member Maloney and members of the subcommittee for the opportunity to testify on Jobs Act 4. The work of this subcommittee to push forward the Jobs Act is a great achievement of Congress and a shining example of bipartisanship and statesmanship. However, there are issues that remain affecting private companies' view of the public markets today. Capital formation and job creation are the NASDAQ's DNA. We brought the capital markets a trusted listing venue and the changed view that companies can go public earlier in their growth cycle, dispelling a common Wall Street perception about when companies should go public. NASDAQ recognized that while most companies wanted access to capital, investors also want access to companies at earlier stages of the growth cycle. In the same vein, since the enactment of the Jobs Act, NASDAQ has created the NASDAQ private market. We established NPM to meet the unique needs and challenges of today's top growth companies. Thus, NASDAQ, we feel, is uniquely qualified to speak about both public and private markets. 4 years have passed and the evidence is clear. The Jobs Act and its success has developed hundreds of companies to go public while generating new dynamics in the private space. In fact, 785 companies have gone public leveraging the Emerging Growth Companies Act and have raised over $103 billion to expand, hire, and compete on a global stage. And approximately 1,000 registration statements have been filed with the SEC confidentially. From our vantage point, the Jobs Act has not resulted in diminished investor protection, an important outcome as you consider moving forward with reforms. Without question, NASDAQ believes the most successful provision of the Jobs Act has been the ability for companies to file confidentially. This has been most evident in the increased number of IPOs from the biotech and life science sectors. Many quality companies have been able to work with the SEC to finalize their registration without public disclosure of their competitive proprietary information, and companies can better manage their decisions to go public as they evaluate market conditions. Because confidential filing has improved the IPO process without decreasing investor protection, we believe Congress should go one step further and allow companies of all sizes to file on a confidential basis and also allow other types of registration statements to be filed confidentially. So turning to some challenges that we see facing public companies today that I hear day in and day out from our listed companies that create a negative light on entrepreneurship views of going public. For example, certain investors who accumulate long positions today are required to public disclosures of their holdings, but there are no corresponding obligations for short sellers to do so, even though the same policy of transparency, fairness, and efficiency apply. We believe that some enhanced disclosure of short positions that matches disclosure for long requirements is warranted. From a company perspective, this lack of transparency has a real negative impact because it deprives a company of insights into trading activity and limits their ability to manage and engage with investors. With respect to proxy advisory firms, we remain concerned that these firms do not always conduct their standard setting in a fair and transparent manner. We are pleased that the SEC issued guidance regarding the use by investment advisors of proxy advisory firms, but it is apparent that much more work needs to be done here. Last year, NASDAQ partnered with the U.S. Chamber on a survey of public companies' experience in the 2015 proxy season. Over 155 companies responded, and it is apparent that companies continue to have difficulty providing input to advisory firms or even having errors corrected. Lastly, with respect to the PCAOB, public companies, especially smaller ones, face increasing auditing costs. While companies do not object to costs that provide equal investor benefit, the companies claim that some of these costs are the result of nonsensical, one-size-fits-all application of guidance and feel they are stuck because auditors claim that they must comply with the PCAOB. For these reasons, we believe the PCAOB should be required to establish an ombudsman's office as a resource for companies to bring up issues that they have. So I want to commend the subcommittee for its continued work to help capital formation with the bipartisan passage of the last 15 capital formation bills, including the RAISE Act, authored by Patrick McHenry and strongly supported by NASDAQ. I also want to thank you, Mr. Chairman, for your leadership in offering an important bill, the Main Street Growth Act, to foster creation of venture exchanges. We certainly appreciate the discussion on this and we look forward to being a participant moving forward. The subcommittee has asked NASDAQ to comment on the 4 proposals aimed at fostering capital formation, and I've done so in my written testimony. We are in favor of the efforts here and look forward to supporting them as they move forward. Thank you very much for your time and appreciate the attention.
Thanks for your testimony. Appreciate it. Next up, Mr. Keating. Welcome. And you got the button pushed. You're recognized for 5 minutes.
Chairman Garrett, Ranking Member Maloney, members of the committee, thank you very much for hosting this important hearing today on the Jobs Act and the need to enhance capital formation, and I appreciate the invitation. My name is Raymond Keating. I'm Chief Economist with the Small Business and Entrepreneurship Council. We're a nonpartisan, nonprofit advocacy and research and training organization dedicated to protecting small business and promoting entrepreneurship. Access to capital has been a key issue, a central issue for SBE Council since our very founding. Indeed, access to financial capital, whether via equity or debt, is vital for entrepreneurs seeking to start up, operate, or expand their businesses. But at the same time, gaining access to capital has remained an enduring challenge for many, if not most, small businesses. Long after this last recession and the start of this recovery, the value of small business loans outstanding is still down notably from the recent high set in 2008. In fact, there's been really no growth over the last decade. When you look again at the small business share of business loans, the value has also declined markedly, also the number of small business loans. On the equity side, angel investment is a critical source of funding for startups and early stage businesses, but here again the story has been one of underperformance and sluggishness in recent years. For all of 2014, the most recent year that we have full data for, those numbers are still down from the recent high hit in 2007. So based on these numbers, the struggle for entrepreneurs to gain access to the financial resources needed to start up, operate, or grow continues to be difficult. There are many reasons for this, including the state of the economy, certainly the policy environment, including regulations, and not just regulation directly imposed on small businesses, but also on financial institutions. After all, they're the source of capital. The bottom line is that small businesses need more avenues to expand access to financial capital. In the midst of these struggles, of course, the Jobs Act was passed by Congress, bipartisan effort, and signed by the President 4 years ago. And the focus here was helping to stimulate the U.S. economy by promoting capital formation. There have been clear positives resulting from the Jobs Act. We've heard some of that already. I looked at an interesting summary analysis done by locavesting.com, and it's outlined in my testimony. One point I'd like to highlight from that is under Title II of the Jobs Act, allowing accredited investors crowdfunding in effect by letting private companies conducting a private placement under Reg D, Rule 506, to publicly market the offering. Before that, of course, they couldn't do that. And we saw the results. They note in Loca Investing that in the first 2 years there have been more than 6,000 offerings conducted under Title II. Of course, Title III goes into effect on May 16th of this year, allowing for public, including non-accredited investors, investment crowdfunding to take place on SEC-sanctioned funding portals, as they say, like Kickstarter for investing. Crowdfunding promises to release an immense pool of capital that has been locked away from entrepreneurs, those entrepreneurs in search of startup and growth capital. Even given the significant and positive changes being brought about for entrepreneurs and investors with the Jobs Act, there are areas in need of improvement. A serious concern persists regarding extra government regulation or placing too many limitations on the ability of entrepreneurs to gain access to capital and/or on investors' abilities to make investments in entrepreneurial ventures. In terms of making headway toward reducing the costs for entrepreneurs, SBE Council supports the 4 legislative initiatives that we are considering here today. In terms of one of those, the Private Placement Improvement Act, that would amend federal securities law to ensure that small businesses do not face complicated and unnecessary regulatory burdens when attempting to raise capital through private securities offerings under SEC Regulation D. We are certainly on board with that effort and the other pieces of legislation offered here today. To sum up, the effort behind the Jobs Act was to expand entrepreneurial opportunities in the financial arena and in the broader economy. Those 4 legislative measures would make further headway in a positive pro-entrepreneur direction. Thank you for your time and attention, and I look forward to answering any of your questions.
And I thank you. Last but not least, Mr. Laws, you're welcome and recognized now for 5 minutes.
Thank you, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee for this opportunity. I'm here as the Chief Operating Officer of AngelList, an online service that connects companies seeking funding with both angel investors and professional investors. Since the Jobs Act was passed 4 years ago and the SEC issued several clarifying letters, AngelList launched what we call our syndicate service. A syndicate allows an experienced, accredited investor who's putting his or her own money into an early stage startup to make that investment available to other angels and professional investors online. The online investors are grouped into a single fund that follows along with the lead investors. Companies like this option because it allows them to deal with just one investor and to raise capital more quickly. And investors like it because they get the protection of an experienced lead investor with skin in the game. All of this was enabled by the Jobs Act and subsequent SEC rulings. Since launching syndicates in 2013, we've helped over $250 million in capital reach early-stage startups. And I know that number seems small by Wall Street standards, but these are the newest companies that just need a little money to get off the ground. That $250 million went into almost 1,000 companies. And we're just one of many such platforms. For example, Circle Up focuses on helping consumer products companies the way we help technology companies, and there are many more. So first, I want to thank Congress, in particular the leadership of this committee, Congressman McHenry, and the White House for the changes brought about by the Jobs Act. It helped many new companies, ranging from those producing electric bicycles to Uber, from Spire Global that launches and rents imaging satellites by the hour, to Cruise Automation, which General Motors just paid over $1 billion to acquire so they can compete in self-driving cars. All of these new companies raised early money on AngelList, all because of the Jobs Act. It not only helped these companies create jobs, but they're also producing innovations that help the American economy. Second, I want to discuss a few of the bills under consideration by this committee. As online fundraising becomes more common because of the Jobs Act, companies are bumping up against the limit of 99 investors acting as a group that can invest in a company. On our platform alone, we've hit that limit dozens of times, leaving tens of millions of dollars that didn't go into good startups. And we're not alone. We represent a small portion of the capital invested in startups. The Angel Capital Association includes many angel groups with more than 99 members. They need to reduce the amount given to growing companies sometimes to comply with this law. Raising the limit to 499 would help with capital formation at that early stage. H.R. 4854 updates the law for today's technologies, but maintains reasonable limits that keep it focused only on investment in small venture opportunities so that there aren't unintended consequences. Anybody seeking to break this law can already do so by ignoring the 99 investor limit, so this law simply provides guidelines for legitimate players to help companies get capital that they need legally. Next up, crowdfunding. While AngelList has worked only with accredited investors the last few years, some of the opportunities on AngelList have been targeted to larger groups of online investors, the so-called accredited crowdfunding. As a result, we devised methods that protect investors' interests while still encouraging capital formation for good companies. Unfortunately, many of those innovations would not be legal for unaccredited investors under the crowdfunding rules. AngelList filed comments with the SEC on the rules, and I've attached that letter as part of my written testimony. H.R. 4855 takes into account the experience AngelList and others have had in the real world with accredited investors over the last 3 years. The investor protections of a lead investor and syndicate, for example, would be made legal for crowdfunding also. Additional measures ensure that crowdfunding doesn't become so onerous that only companies accredited investors don't like would use it. I applaud the goal of preventing fraud, but we have to do it in ways that don't simply guarantee low returns for the crowd while giving wealthy investors first look at the good opportunities. Finally, on H.R. 4852, the Private Placement Improvement Act, I've also included our letter to the SEC in my written testimony. We support the SEC's stated goals of information gathering and transparency. Unfortunately, the draft regulations currently under consideration wouldn't just measure, they would adopt rules that startups would most certainly violate by accident. For example, startups don't have the money to hire lawyers before they raise the money, but the proposed rules say they should already know they need to file 15 days before even mentioning their fundraising, something they would only learn from their lawyer. In our letter, we propose several ways the SEC could use technology to achieve the same transparency without impairing early-stage fundraising. These more modern methods would still be viable under H.R. 4852, which we support. In closing, I'd like to thank you for this opportunity to share our experience with the Jobs Act. The startup community deeply appreciates your continued attention to the issues affecting capital formation for very young companies. This is an unusual issue because most startups that will benefit from your work don't exist yet. With your continued support, we hope thousands more of them can make use of the Jobs Act to do what Congress intended: raise capital more easily so they can grow, create more jobs, and innovate. Thank you.
Thank you. So this is fascinating. I appreciate all the members on the panel. So I'll begin with questions, and I'll begin recognizing myself for 5 minutes. So we'll start with Mr. Atkins. You touched upon this both in your testimony and just right now as well, with regard to the proposed new restrictions of Reg D, and including requirements as far as filing Form D and before an offering is completed. You also just mentioned the fact as far as the one-year ban on offerings. So I'm going to give you 1, 2, 3 quick questions to recapitalize that. A, do these requirements that are out there do anything to enhance investor protection? Secondly, from your viewpoint, is the mere existence, and you sort of touched on this, of these proposals, even without the SEC implementing, putting a lid on the 506C market, and C, is this doing, I'll go back if you want me to, C, is this doing anything that's burdensome now to your colleague next to you as far as the state regulators doing their jobs if we don't go in that direction? So the first thing is this doing anything to advance investor protection, what the SEC is doing?
Well, I think when you look at, the SEC's own statements from its economists and whatnot, they show that there really is no fraud coming out of, the Jobs Act, and especially 506. So I think that's attributable to it. So I think, I don't think that these things are advancing investor protection at all. I think that what, if anything, it's dampening.
That's the second point. Is you said it is dampening because why? The attorneys are recommending to them what?
Right. They're not. They're basically they're saying that you should not use 506C because of the uncertainty behind it, and there are other ways to do it. And so it's really putting a damper on the ability of people to to make use of the Jobs Act provisions.
I'll throw that same question over to Mr. Griggs if you were listening to it at the same time. In general, to go down to 3 points, as far as there a dampening effect of the proposed rules, on the flip side, should we have it for investor protection?
I think that from my
Actually, that was-
conversations with the lawyers in my community, I'm sorry.
I was going to Mr. Griggs, actually.
I'm
on that one.
sorry, I
That's okay.
misheard.
That's okay. Mr. Griggs?
Yeah, NASDAQ is not very involved in Reg D offering. We don't feel that investor protection, though, as we've seen it, has been harmed in any way. So we are supportive.
Okay. And I'm going to jump down to, well, to Mr. Laws on where you were going. So one flippant sort of response to the problem of, you raise a really crucial aspect, is how do these people get into the marketplace and how do they know what the rules are without the lawyers there beforehand? How do they get the money to hire the lawyers? Should we have a legal aid society for these programs? I'm just being facetious on
There
that.
do exist such things that the startups, when they first do their fundraising, don't even know those exist. That's the first thing they think of when they start. So it's...
Gotcha. So Mr. Keating, right now, maybe right about now, there are oral arguments in the challenge to the SEC's final Reg A Plus is set to begin this morning in the D.C. Circuit Court. And as you know, as the Jobs Act was being developed, many reports, including one from the GAO, pointed out that the maze of state registration requirements was a direct cause for the lack of Reg A offerings over the years, and that's basically what we've been sort of hearing this morning. So in your testimony, you refer to Reg A Plus as a sleeper of the Jobs Act. Can you just delve in a little bit more as to what the effect on the Reg A market would be if the state challenges prevailed in the court arguments today?
Sure. Well, the bottom line is, why has Reg A Plus worked, right? Providing various relief from, as you mentioned, the regulations you mentioned. So, yeah, I'm an economist. I like to look at the results. So when you see reports that in terms of this being the sleeper and in terms of entrepreneurial ventures that have found funding where they wouldn't have found funding before, for example, this is exciting stuff. This is exactly what we want to see done. Why would we want to backtrack on that from what I can see, no good reason from an investor protection standpoint? Or, you don't want to get caught in that regulatory turf game that we see so much in government, which may be the reason behind some of this.
So I'll throw this out to a couple of you. Maybe I'll start with you. So you say you like to hear the data and what have you. Mr. Beatty was raising the argument that so would he, that he would like to have the data before we move forward on a number of these and certain one of these provisions on the state level and see how it plays out first. So is that an argument? Maybe we should just be waiting on this and just put a hold on it, let the SEC continue?
Yeah, because we've seen results, as I mentioned in my testimony, the results of the various titles.
So the results are in.
Going on, right. So we see results, we see positive benefits. And not just, here. There are examples internationally. I mentioned in the testimony the United Kingdom and what they've done there, and the tremendous growth we've seen in crowdfunding, both debt and equity crowdfunding there. And they've done it very smart from a regulatory standpoint, relying very much on the crowd, if you will. So there are plenty of examples for us to understand. And then there's also just plain old, as an economist, fall back to Economics 101 and understanding incentives and how the private market works. And are there incentives to present, a good, solid platform that provides great opportunities for investors?
So the two takeaways is it's working and Congress needs to go back to Economics 101 class.
Yes.
Okay.
Yes.
With that, also a flippant comment, I will now recognize the gentlelady from New York for 5 minutes.
Thank you, Mr. Chairman, and I ask unanimous consent to place in the record testimony from the University of Denver.
Without objection, so ordered.
Okay, Mr. Beatty, I'd like to ask you about the Micro Offering Safe Harbor Act. In your testimony, you said that this bill would expose retail investors to, quote, literally unlimited investment risks, end quote. Can you talk about why you think this bill is so broad? Is it because companies could sell unlimited amounts of securities to buyers that they have a pre-existing relationship with? Is that the main challenge that you see with this bill?
Yes, it is the main challenge I see. Creating a substantial pre-existing relationship is not a hard task. Certainly we've seen it down through the years through SEC interpretations where an issuer can create a relationship to investors by dealing with a broker-dealer who has established a relationship. More recently, we've seen basically advice that seems to authorize the idea that a relationship could be established through an issuer questionnaire.
If I could follow up
Certainly.
on that, would your view of the micro offering safe harbor bill change if a company had to comply with all three of the requirements in the bill in order to take advantage of the relief? In other words, what if the bill was limited to 500,000's worth of securities a year to no more than 35 investors, and they all had to have a pre-existing relationship with an officer of a company? Would that?
I think it makes it better. I think if the true purpose here is to create an offering for micro type of offerings, that already exists. Rule 504 has been around for decades, allows offerings up to $1 million with a very simple filing. I would also note that many states, almost all states that I'm aware of, have specific, small offering exemptions for these types of very small capital raising, usually with a very minimal notice filing and very low fees.
In your testimony, you noted that you had serious concerns about the Private Placement Improvement Act because it would weaken the few existing investor protections in Rule 506. Can you elaborate on which investor protections this bill would weaken, and which protections do you think are the most important? Do you think these investor protections are particularly onerous for companies? In other words, are any of these protections really preventing any companies from raising capital?
Well, I think the one of the main features of the Improvement Act would be to would require only one filing of the Form D. Right now, there is a requirement to file amendments, and of course, the proposed rules posited the idea of perhaps a pre-filing in the case of a general solicitation. The only data we have available to us in the state on these types of offerings is the Form D. And unlike the SEC, we look at them. We run the officers through databases. We check on who might be selling them. We are concerned about these offerings, and many times they're conducted lawfully, but once in a while we'll find something. And perhaps more importantly, if an investor is solicited and they are unaware have questions, they pick up the phone and they call us. And if the only thing that we can say is, well, we don't have any information about this, you should be careful, that's really not providing a very good service to our constituents.
Okay, thank you. Thank you. Mr. Keating, the SEC just recently completed its crowdfunding rules, which are set up to take effect next month, and I was a Democratic sponsor of the original bill. Should we wait until we have some experiences from crowdfunding before we move forward with other significant changes in crowdfunding exemption? And also, you mentioned you had studied what had happened in England. Has crowdfunding been used not only for the private sector, but for public purposes, for not-for-profits? Have they used crowdfunding for public service endeavors also in England, or is it just limited to private sector investment opportunities?
I can't speak to that. I know early on during this whole process, one of the examples that was mentioned for crowdfunding was the Statue of Liberty, the money being raised on that front.
Yeah.
That was done in that
I think it could be public funding too.
Right.
Don't you think we should wait a little bit before we come forward with all these changes?
No, because I don't.
The rules haven't even gone into effect.
No, I don't. I mean, and the reason is, like Mr. Laws mentioned, we're talking about the entrepreneurs here that drive our economy, that create jobs, things that we desperately need. We desperately need more growth and more jobs in this country. So why would we want to, for example, have any kind of, again, within the boundaries of what we laid out so far legally, but why not extend the opportunity to more people? Why would we want to leave money on the table, if you will, for those looking to raise funds to build businesses and create jobs? So if there's an opportunity, for example, in crowdfunding in Title III to raise the limit, yes, I think that's a great idea, because this is my job. My job is to open more opportunity for small businesses by reducing their regulatory burdens, and I think that's a great idea.
The gentlelady's
Time's
time is
expired.
expired. Thank
Thank
you.
you.
Thank you for the question. We are joined now by the sponsor of the McHenry bill, Mr. McHenry.
Thank you, Chairman Garrett, and thank you for having this hearing, Mr. Chairman. Thank you all for your testimony, and I'll begin by asking Mr. Keating a question. You say that angel investment is a critical source for startup and early stage business capital, but you also note that angel investment is still sluggish. What are the dynamics at play?
Yeah, it is sluggish, and we're you know I've laid out some charts in the written testimony. I think there are all sorts of dynamics at work here. I mentioned the state of the overall economy, but you've got to look at issues on the public policy front, and I think you've got to look at regulation and how much uncertainty is created. What are the costs? Unfortunately, when you plug this whole, you have to, from a small business perspective, you have to plug this whole debate into the overall regulatory picture. And that's been a very ugly picture from a small business perspective in recent years. So where we either have uncertainty in so many areas, or where we don't, we have increased costs. The Jobs Act has been a wonderful exception to that, where it was a deregulatory effort, a reform effort that really expanded opportunity for small businesses to get access to capital. So yeah, I think part of the question on the angel investor front comes from the regulatory aspect, absolutely.
So, as an economist, you can perhaps state this more succinctly than I, but if you're capped at 99 investors, you have to have 99 much larger investors and perhaps 150 smaller investors, and there is a cost associated with that, is there not?
Absolutely. As I said, you don't want to, from a small business, pro-growth, pro-entrepreneurial perspective, you don't want to be leaving anybody out of this equation that obviously that understands what they're getting into. And it's important to mention, fraud is thrown around a lot, but fraud is not the same thing as risk in the marketplace. It's not the same thing as business failure. It's not the same thing as losses. Those things are all going to happen in the real world of business, so as long as people understand that.
Mr. Laws, to that point, in your experience, this 99 investor cap, coordinating investment pools in conjunction with that, I had this example presented to me yesterday that one group decided they would only have 84 investors because of the length of the hold, they believed that there would be deaths and divorces, and as such, that number would rise, and they didn't want to imperil the longer-term hold of it. Are there examples like that that you could mention to us today?
Oh, most certainly. So I've mentioned it as a 99 investor limit. We happen to, at the advice of our lawyers, use a 90 investor limit for that exact reason, because the courts will sometimes force you to add new investors when they split somebody's holding because of a death or a divorce in an inheritance situation. So it's actually, for practical purposes, a 90 investor limit or 84 investor limit in this case. And we're just hitting it more and more often with sophisticated accredited investors, I should specify. This is still within the sophisticated accredited community.
So shifting to the Fixing Crowdfunding Act, there's been discussion about the problems with Title III as enacted and the problems with the over 500 pages of regs that the SEC has written. So, Mr. Laws, in your opinion, if Congress doesn't amend Title III of the Jobs Act, will its intent actually be useful?
I think it's actually a little dangerous as it exists now, primarily because of this risk that what will create is a kind of guaranteed set of bad investments. They won't be fraud, they'll just be bad investments, because it will be used by companies that can't raise using the Title II of the Jobs Act. And so I'd want to make sure that the crowd gets an opportunity to get into the good investments. So it's something that the fixes will help balance the investor protections with making sure that the good investments will also use Title III.
So at current pace, you see this as a potential marketplace for major problems?
I think it's a danger. I think there are some good companies that will use it, primarily for publicity. But I don't see it yet as something that is a true alternative to Title II for those companies that have access to Title II.
So what's the most important thing or two that you would point out in terms of our action here in Congress?
I think the most important for that side of it are, first of all, being able to bring in some investor protections, frankly. There's one section in the Fixed Crowdfunding Act that adds the ability to create these syndicates, the funds, where a lead investor looks out for the interests of the crowd. The other is this notion, the 12G problem, so-called, where as soon as you cross 25 million in assets, if you have a large enough crowd, then you have to start registering the same way a public company does. 25 million is the next financing round for a successful company. So if you are a high-growth company, you would now avoid crowdfunding because of the danger of as soon as you raise your next round from a VC, suddenly you're not private anymore. So I think those are two of the primary ones.
And the gentleman's time has expired. I thank the gentleman. Gentleman is recognized from Massachusetts.
Thank you, Mr. Chairman. I want to thank the members of the panel. I'd like to talk about 4852, the Private Placement Improvement Act, so-called. Mr. Beatty, the Form D, is that required, right? Is there a penalty for not filing a Form D?
There is currently no penalty for failure to file a Form D.
So any talk that we've heard on the panel today about the problem of filing this and the encumbrance on companies, they don't have to file this, and there's no penalty if they don't file it, right?
No, I believe that there may have been one instance where the SEC might have taken action on the failure to file, but it is widely regarded as not an essential form to file, and I believe that in some places it's routinely not filed.
Right. However, I do know from talking to some of the state secretaries of state and attorneys general that this exemption under 506, Rule 506, it is and I'll quote here, it's reported as the most frequently reported fraudulent product or scheme involved in enforcement actions by state securities regulators.
Yes, that is correct. In our surveys, in terms of what types of action states are taking and what is being reported to us in particular, 506 comes up, I believe, is the second most popular thing that comes up. That's not surprising.
Popular meaning what? The most
more frequent, yeah.
Fraudulent product,
Yeah,
right?
And it's not
second most. Okay.
Yeah, it's not the most. It's not surprising given that it is the vehicle of choice for raising capital in this country.
Right. Form D is just 4 pages. It's not a whole lot of.
It's actually 8 pages with
well,
3
there's
pages.
4 pages of instructions.
3 pages of instructions, 8 pages of question and answers that need to be filled out.
Okay, maybe I don't have it all then. Still, fairly brief and not very complicated from what I can see. As far as enforcement of Rule 506 and the exemptions, what is the wisdom of preempting states to protect small investors? I don't get that. I do think that, as Mr. Keating says, he's got a job to do. But I think that protecting investors from fraud is also part of the job as well. And Mr. Laws, this is great. This new idea, crowdfunding. It's very exciting. But if we get into a situation where it's seen as an area that is rife with fraud and people are being taken, I think we might have a big disincentive of people getting involved, small investors especially, who are not sophisticated. Mr. Beatty, what about taking the state regulator off the street here and preempting them from conducting enforcement actions?
Well, I think that certainly enforcement is a big part of what states do. and anything that hinders our ability to bring enforcement actions in the appropriate cases is problematic. I think that in the Rule 506 area, we've long been preempted since 1996 from requiring any type of doing anything except getting a notice filing, and we certainly have fraud authority. But the question is to us is we appreciate the fraud authority, but enforcement actions take place when people have already lost money, have already been harmed, their retirement savings have taken a hit, maybe they can no longer send their children to college.
I only have 38 seconds left. So the bill that is being offered today by Mr. McHenry would only require filing after. There would be no pre-filing submission, so that investors wouldn't be able to look at this until after the offering was made. Is that right?
Well, the current regime for 506 is a post-sale filing. If we're talking about the micro offering act, that calls for no filings whatsoever with anybody.
Wow. Okay. My time has expired. I yield back. Thank you.
Gentleman yields back. Vice Chairman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Griggs, I was interested in your testimony and your statement that in support for the Jobs Act generally, talking about the resounding success embraced by investors and companies, and especially interested in your statement that the Jobs Act has not resulted in any trend that diminishes investor protection, which I think is critical. Also in your testimony, you said that there are provisions, however, of the Jobs Act that are scarcely used because they run contrary to investor expectations. I was wondering if you could talk a little bit about that.
Sure. There were a handful of things in the Jobs Act, most notably the ability for companies to reduce the years of audited filings from 3 to 2. And I think market dynamics have taken over there, and really the investment community has an expectation for 3 years. So companies, the overwhelming companies that we work with or talk to, and the advice of their different parties who are taking them public have not taken advantage of that. It really, if I had to go back to repeat a point, it really is the confidential aspect of filings that has been overwhelmingly well received across the entire community. There was concerns that is 21 days enough for the investment community to really understand the investment, and I think from the perspective of what we hear is clearly it is, so that has done no harm whatsoever.
And then the other thing I noted in your testimony was talking about the beginning of 2016 so far, that it looks like IPOs are at a not coming online as quick as much as we would like to see. Can you talk a little bit about that, and what are things that we can consider to help increase those?
Sure. That really started near the end of 2015. I like to separate the market conditions versus companies' desire to go public. So as a statistic for you, in the first quarter of 2016, we received just as many applications for companies to go public as we did in 2015 first quarter. So there's still a very strong demand for companies to go public, but across all sectors right now, due to the overall public market volatility, I think it's very cyclical right now. You have public companies, their valuations have come down. So we have seen across all sectors a general, again, I would call it more a cyclical freeze in companies going public, but by no means should this indicate there's not a desire to go public or company is still leveraging those key components of the Jobs Act. So we do feel that there's going to be a bit of an opening here, hopefully in April, May, which will lead to a better second half of the year. But it's market condition, not a regulatory issue.
Excellent. And then I had a question for Mr. Atkins and Mr. Keating, sort of more of a general nature, but when you think back on the recession in 2008, and then you think about Washington's response to that in the form of Dodd-Frank, can you talk a little bit more generally about how important the Jobs Act and having having policymakers take a close look on how you streamline regulations, reduce unnecessary burdens from a regulatory standpoint, how important that is in light of what Dodd-Frank has given us? Because I represent a rural district, 23 counties and cities. We have a major university in Charlottesville where we have small businesses that are eager and looking for capital, but because of Dodd-Frank, have had tremendous difficulty in accessing capital. And so the kinds of things that we're working on today, it seems to me, in a way, acknowledge, I think, some of the significant shortcomings of the overregulation that came out of Dodd-Frank, and speak to the necessity of making it easier to hook up investors with small ventures. And I'd love to hear from you, Mr. Atkins, and then Mr. Keating from an economist standpoint.
With 45 seconds, we could talk about that for a long time. You know, Dodd-Frank with 2,319 pages itself was only part of it. Then it had mandates of up to 500 rules and studies from the different agencies. And so a lot of that, still has not been implemented yet. At my old agency, the SEC, they're still maybe a little bit more than halfway finished. So the huge amount of work that still has to be done, the uncertainty on the industry. Just the other day, I was approached by an investment bank with a new offering of a fund to invest in that would basically take away from small banks, community banks, loans that they can't carry on the books anymore because of the examiners from the Fed and elsewhere putting a lot of pressure on them not to make loans to small business anymore. Janet Yellen has basically said the same thing in testimony before Congress. So it's the uncertainty and the cost that Dodd-Frank has imposed on the industry that has had ripple effects, which is why really we need to look at things like the Jobs Act, new ideas that will help spur capital to small business.
Mr. Keating, I apologize. My time's expired, so
I agree.
Cool. Thank you.
Best
I yield
answer.
back.
The gentleman yields back with a short answer. Gentleman from Connecticut is recognized.
Thank you, Mr. Chairman, and let me thank all of you for being here to have this conversation. I want to just make a couple of observations and ask a few questions. To be clear, I actually voted for the Jobs Act. I had some misgivings, but in the end, I thought it was a good compromise. I'm always taken aback, though, when this topic is shoehorned into the debate that this institution has so often about where exactly the boundary line of government regulation, interference, presence should be. It doesn't really fit. We can eliminate all regulation on the issuance of new securities. That'll make it an awfully simpler process for businesses to do capital formation, unquestionably at the expense of the other half of our economy, which are the investors. So it seems to me that this is a problem of really balancing the interests of two absolutely essential elements of our economy, the people who need the capital and the people who are offering the capital. So I get so confused when the presentations are shoehorned into this world where, in this case, in this panel's case, if we just do everything for those people who need capital at the cost of those people who provide, well, everything will be fine. We know that's not true. So I want to make that observation because it just drives me crazy when good work gets caught up in this deregulatory fervor. The question I want to ask, just to bring this point home, it's well known that most instruments that are available to retail investors, mutual funds, equity mutual funds, most managers, professionals of equity mutual funds don't beat the market index. So I guess my question is, in particular for those who are so enthusiastic about pushing the boundaries of the Jobs Act, can anybody here tell me that they're sure that retail investors, because that's who we're talking about here, that retail investors, setting aside the issues of fraud and 404B and what companies are actually more prone to poor compliance, that's a whole other story, but are retail investors going to make a lot of money in crowdsourcing, crowdfunding? Can anybody here on the panel tell me that your average middle-class family out there with, let's just say, I don't know, $10,000, $20,000 to invest, would anybody here recommend that a middle-class, retail, unsophisticated investor ought to put $10,000, $20,000 into a private placement or a crowdfunding deal?
If they do their homework, I see no reason why middle-income America cannot do their homework and make wise investment decisions.
But you think think they'd make money. Would you
think some
advise
of the- I think
would
some
you
of them will-
advise a retail investor to put money into a index fund or into some local crowd-funded?
Not a
business?
financial advisor, but I would say that if you've got extra money for investment purposes and you think you want to support entrepreneurial ventures, perhaps some in your state or your district or your neighborhood, and you have that opportunity and you choose to do that and you do your homework, that's great, go for it, and I hope you make a lot of
Okay,
money.
but that's not my question. My question is, and you've got some economic background, is that individual likely to outperform an index with that as an investment strategy?
I don't know if there's data available for me to answer that, but what I can say is on an individual basis as an economist that if you do your homework, you're going to, listen, investment, there's no guarantee here. I said very much during, the outset that you have to recognize the risks. You have to recognize
I understand.
that
You're not
businesses-
actually answering my question. I appreciate what you're doing, but you're not actually answering
Well, you asked me would I advise somebody, and I said, yes, do your homework, be smart about it, and yes, go ahead and make the investment if you think that's wise.
Right, okay. I got another important question here, but the fact is that the average professional mutual fund manager doesn't beat the index, so I'm going to preserve some skepticism about whether a retail investor, homework or no homework, is going to do better. I have one other question, though, which is, and I appreciate what the Jobs Act has done. We apparently are saving companies a lot of money. I did a lot of work on this, and people assured me that full Sarbox disclosure was going to cost $1 million or $2 million absent the Jobs Act. I want to ask a question, which is that the average IPO gross spread, which the average IPO, let's just say it's about $200 million, a little less than that, $200 million. Gross spread, 7%, that's $14 million. 95% of all IPOs in the United States since 2008 have had a 7% gross spread. $14 million has gone to the underwriters. Why is that?
Well, actually, Congressman, I think that's what crowdfunding and other things is really exciting. It's a disruptive, new technological way of trying to raise money that will then disintermediate investment banks and other banks and maybe save companies that are raising money and their investors a lot of money over time, which is kind of an exciting thing, and so why not try it? I think that's the one thing that we're talking about here, and I'm as troubled as you by what you're citing.
And so if the chairman will indulge me just for a few more seconds here.
We're just over time for everyone's. We'll do
all right,
circle
thank you,
back.
Mr. Chairman. Thank you.
Gentleman from Texas is recognized.
Thank you, Mr. Chairman. I want to kind of pick up this line of reasoning because it's one of the things that I'm very concerned about all across this government is we've gotten into a mode now of the government telling people what is appropriate for them and what is not appropriate for them. We've got a CFPB that is out determining what kind of financial products that ordinary consumers should have, and so now we're trying to tell people whether they're smart enough or not to be able to make certain kinds of investments. And one of the things that I think is very troubling to me is that the little guys have not had an opportunity in the past to get in on some of these, wonderful companies that were started, in a garage or in a dorm room. And so I think one of the things that I wanted to mention, Mr. Laws, in October, the SEC finalized its rulemaking obligation under Title III of the Jobs Act, but unfortunately imposed new restrictions on crowdfunding that Congress did not mandate, which could prevent Title III from reaching its full potential. And the issue there is that SEC placed arbitrary caps on the amount that individuals can invest in companies based upon the lesser of their annual income or their net worth. The new crowdfunding rules are set to go live in 2016. As you know, Commissioner Penawar dissented that decision. So I guess the question I have is how do we determine what is appropriate for investors? Should the government just publish a list? These are things that we think are appropriate for people to invest in, and these are amounts, and just take that decision away from the individuals?
I will honestly say I don't have an opinion on that. I do have an opinion mainly that because when accredited investors participate in a crowdfunding, You can have some very wealthy investors who are also affected by the caps, but would not be affected by the caps if they went directly. I believe the changes in the Fixed Crowdfunding Act are aimed at allowing accredited, sophisticated investors to do larger amounts of money, not necessarily at allowing individuals who don't have as much money to invest more. So I realize that doesn't quite answer your question, but I do believe that the changes are productive.
Mr. Keating, you have an opinion on that?
Well, I think by definition they're arbitrary. I think you are better off leaving it to individuals to make their own decisions. And it's also important to understand that with crowdfunding, investors are warned of the risks on the portals. So they have to go through a test. So they're going to be made even more aware of the potential risks involved. But yeah, I default to the American people and the individuals over choices made by the government, yes.
I mean, the observation from my perspective is we make it difficult for the little guys to get started. And we also make it difficult for some of the little folks, you know, to get in on those kind of investments. And quite honestly, you know, mutual funds and exchange-traded funds and stuff, people lose money on that too, right?
Absolutely, and your point about the little guy on both sides of the equation is what we're talking about here. We're talking about not just the small business getting access to capital, but the small investor having that opportunity where they didn't have it before, to be able to get in on the next great thing that's coming, as you said, out of somebody's garage.
Mr. Griggs, one of the things I was wondering, in looking at market activity right now, what the private placement, do you still see a lot of companies, because some of the barriers out there, still opting for trying to do private placement?
Yes, absolutely, especially with the dearth of availability to go public right now. We do see many companies taking advantage of private placements, as it's a very large market, so it's very active right now.
And so when is there, do you think, has anybody done an analysis, does it raise the cost of that capital sometimes to be forced into a private placement, as opposed to being able to look at a more market-based activity pricing based on the market being able to go public? Does that make sense to you?
We don't have a specific date on that, but certainly anytime you're going to raise money in a more liquid market, the cost of capital is going to be lower. So private placements are not going to be as liquid, so that is the case.
Okay. Thank you, Mr. Chairman. My time has expired.
Gentleman's time has expired. Mr. They've gone. Mr. Carney was next, so.
Mr. Carney's been waiting. Let's go to Mr. Carney.
Go to Mr. Carney then.
Thank you, Mr. Chairman. I thank the gentleman from California, because I do have to go. I'm going to resist the urge to get pulled into this debate about what the government should or shouldn't tell small investors, but I would like to associate myself with the comments by my friend from Connecticut, Mr. Himes. I voted for the Jobs Act as well, and I worked hard with Mr. Fincher, my friend from Tennessee, on the IPO on-ramp part of it. And there were a lot of folks in the industry and in my state who had worked on it and expressed a concern about it. Delaware, as you may know, is the place where most of these companies are incorporated. And my friends in the Division of Incorporation had alerted to me to what they were seeing a couple years ago with the lack of companies going to an IPO, and we know that has those public offerings have increased since the Job Act passed, and there was some testimony that each of you made with that respect. I thought that the 404B audit question would be one of the things that the IPO on-ramp provided a 5-year phase-in, and that would be the biggest thing that some of these emerging growth companies will look to in choosing to go do an IPO as an emerging growth company. But actually, as was mentioned earlier, I think by Mr. Griggs, it's the confidential filing piece that we hear is the most important part of that IPO on-ramp. Mr. Griggs said that we should allow all companies to file confidentially. Mr. Beatty, do you have a view of that?
Sorry. I think that certainly that it presents challenges, I think, from a regulatory aspect and a transparency access to allow all companies.
What would those be at a real practical level? I mean, the attractiveness of it from the other side is a company can do that, test the waters is the terminology that's used, and not have to give up, concerns about their IP or whatever it might be. So what would the concern on the other side of the scale be with respect to that idea?
Well, testing the waters, I think, is an idea that has been around for a long time, and states have embraced it, many years ago in many respects. And if it's done properly, I don't think it imposes much by way of concern in terms of investor protection. The things that we worry about in testing the waters is how open the communication will be in terms of will it be something that is something that somebody says that is completely untrue? Is it not a good faith effort to try and gauge interest, but instead an effort to try and draw investors in a way that's inappropriate? Protections that are put in place in terms of requiring some type of filing first, having some type of waiting time between the testing the waters communication and the actual offering. I think those are all good measures that help solve some of those problems.
Great. One of the provisions in the JOB Act that did concern me was the crowdfunding aspect for concern about fraud and vulnerability of unsophisticated investors. And I'd just like to ask Mr. Laws, Mr. Keating, we really don't have, as Mr. Beatty said, any federal experience here. Why should we change the rules now before doing that?
So I actually would disagree with the premise, because the so-called accredited crowdfunding has been legal since the Jobs Act passed and some of the SEC rulings. So since the Jobs Act passed, we do have a good 3 years of experience of some of the techniques that seem to work well in accredited.
So do those apply to the investors that I'm most concerned about, the unsophisticated investor?
I believe so. One of the more important aspects, for example, of the Fixed Crowdfunding Act allows this structure of following after a sophisticated investor putting a larger check in and having them look out for the interests of the other investors, which would not be legal under the current act. So I think we could apply some of those learnings with this bill to improve the crowdfunding for the unaccredited investors.
Mr. Keating, I got 24 seconds.
Well, I think it goes back to the crowd aspect of crowdfunding, right? The wisdom of the crowd here is critical, and technology allows that where it didn't, certainly in 1933 and 1934. So the fact that you've got these communications and you've got the crowd evaluating these investments is central to the whole effort.
Great. Thank you all for being here today.
Thanks. The gentleman yields back. Mr. Holken is recognized for
Thank you, Chairman. Thank you all so much for being here. Appreciate your time and expertise in this important discussion. I want to initially address my first questions to Mr. Adkins, if I may. Earlier this year, you wrote an op-ed that ran in the Wall Street Journal. It was titled, "Equity Policy Needs Surgery, Not Band-Aids. Volatility, flash crash risks, and bigger dark pools are the legacy of the SEC's regulation NMS." This, of course, was with respect to IEX's application to be a registered national security exchange. I've commented on IEX or commended IEX for putting forth ideas considered by some to be effective adjustments to our market. But I've also remained unsure about how the investor exchange would function in already complicated market structure. In your op-ed, you remarked about a broken process at the SEC, and I will quote your op-ed, where you said, "Will the agency address equity market structure concerns comprehensively, as many members of Congress and SEC commissioners say is necessary, or will it make these far-reaching policy decisions in an opaque exchange application approval process?" End quote. Over the last few months, there have been some developments where your perspective would be valuable. One, the extended comment period for IEX's exchange application, to which they have made some modifications, ends today. Also, the comment period on the notice of interpretation for whether a 1,000 microsecond delay should be de minimis for the purpose of Rule 611, the order protection rule, ends today. So my first question, Mr. Adkins, I have been frustrated with the Commission that it's been slow to act on changes to market structure, but do you think in general changes to market rules through an exchange application process will result in good public policy?
Well, well, thank you for the question. And I stand by what I wrote in the journal there. I think, what the SEC should do is take a total review of NMS. There were a lot of things that were put forth back there 10 years ago that did not make sense then and don't make sense now. And I can see, the impetus behind trying to let a new entrant into the marketplace, but still it needs to be done in a transparent way.
Following up on that or continuing, the New York Stock Exchange recently filed with the SEC to use a replica of the discretionary pegged order that is included in IEX's application, which was made public through an exchange application process. Does this raise intellectual property concerns? It would seem the New York Stock Exchange could potentially make use of the DPEG before IEX is granted exchange status, which would disadvantage IEX.
Yeah, so that's part of the whole issue here where, if you treat people disparately and in a manner that doesn't apply to everybody, where you run into those issues.
Yeah. Furthermore, isn't the use of the DPEG and a notice of interpretation on the definition of immediate evidence that the exchange application process is being used to rush consideration in changes to market rules? And would notice and comment rulemaking, not just an interpretation, be more appropriate?
Yeah, I don't know that much about that particular issue, but I think in general, the Administrative Procedure Act really should apply in this area.
As a free market conservative who wants to see competition and innovation rewarded by the markets, what advice would you give to IEX and its supporters?
Well, I think they have created an innovative exchange where lots of investors and traders like to go. So, hats off to them. And so, what I really encourage the SEC to do is take a really robust view of NMS and the whole process, and do it in an open manner and not just on a one-off exchange application basis.
Good, thank you. Switching gears a little bit, I'm going to address my next question to Mr. Keating. I've got some questions about implementation of the Jobs Act. What are the most burdensome provisions of Title III in the Jobs Act, and do these burdens make crowdfunding useless to small businesses seeking equity financing?
I'm sorry,
What are the most burdensome provisions of Title III in the Jobs Act, and do these burdens make crowdfunding useless to small businesses seeking
well,
financing?
I gotcha. I don't know if it makes it useless, hopefully not. But certainly I think the limitation, but also on the portal end of things, clarity on their liability, issue, I think is crucial, and it is addressed in one piece of legislation here, and I think that is certainly a big issue in terms of competition on that front and a flourishing number of portals. And by the way, to really plug this very quickly, but crowdfunding demo day on May 16th, SBE Council is part of a group that's going to be here in Washington giving demos on everything that we're dealing with today, and I urge everyone to come. So there you go.
Great. My time has expired. I yield back. Thank you, Chairman.
Gentleman, time has expired. Gentleman from California.
Thank you, Mr. Chairman. I'm very old. I was around when Reg D was the new thing. And we were so impressed to think that, well, we're not giving accredited investors incomes of over $200,000. That was a tiny group of people who must be incredibly smart to be making that amount of money. Now it's an amount of money scarcely more than congressmen and federal judges make. Now we're here, for the most part, relaxing standards, providing less protection to investors so that we can provide an easier path to providing capital for business. But if Reg D made sense back in, 1982, then it can't make sense now, and vice versa. Because if it made sense to put the limit at $200,000 then the income level should be $600,000, $700,000 now. I know that there's been discussion of indexing going further, but Mr. Beatty, have we opened the door too much by deciding that $200,000 or $1 million in assets excluding home is the definition of an accredited investor who can afford to lose a lot of money?
Well, I think you have to start from the premise that the idea behind defining accredited investor and putting those limits in place was supposed to be a proxy for investor sophistication. Indeed, in many of the cases that we deal with nowadays, a fair percentage of the investors that we see that have been harmed are indeed accredited investors. So it's an imperfect proxy. NASA has long advocated for indexing.
Mr. Beatty, was it more of a proxy for ability to absorb the loss?
That has been posited as well.
Or a proxy for knowledge, or at least the ability to hire it?
Well, I was not around in 1886, or 1882, but yes, it has also been put forth that was attempted to be an amount of money that an amount of assets or net worth that they could absorb a loss.
And does it make any sense if those were supposed to be the limits then? What should the limits be today?
Well, I think you need.
I realize that some people who make an awful lot more are unsophisticated, and some who make an awful lot less are very sophisticated. But we still have a rule based on income and assets. What should be if we're going to have a rule that talks about an accredited investor and looks at income and assets? Where should we draw the line?
Well, I think that certainly from my organization's standpoint, we have long advocated for indexing those amounts to inflation. If they had been indexed, I don't have the numbers right in front of me, but I believe that it would be roughly 2 to 2.5 times what they are now.
More than that, but
okay.
Go ahead.
Other ideas that have been put forth questioning whether or not income or net worth is the appropriate standard. Also, they have been discussed, and I think there's some appeal to looking at things such as some type of liquidity factor that an investor might be held to in terms of liquid assets, amounts in a portfolio, things like that.
Mr. Atkins, do you have any comment? And is it enough for us to just index these numbers from 2016 forward, or do we need to index them from 1982 forward?
Well, I wasn't actually around when Reg D was adopted, but I was just beginning to practice law, just about to get out of law school. So, things have changed a lot since 1982. We have a lot more communication, a lot more sophistication where people can actually go and get information. But if somebody can invest 100% of their net worth in Valiant and to watch the stock crash overnight, in a single stock, that's one of the most risky things that one can do versus some of the other alternatives. So one of the things that really impressed me back when I was a commissioner, when we were talking about raising the this limit, was a comment letter where investors said, I can invest in a hedge fund today, but tomorrow if you raise the limit, I won't be able to.
Let me just...
Time has expired of the gentleman from California.
Thank you, Mr. Chairman. In California, as you know, we've got a world-class network of startups from Silicon Valley to Orange County, and the issue of access to capital for startup businesses, this is critical. This is critical to our state's economy, but critical also to ensuring that our country remains the best place for entrepreneurs, not only to get the entrepreneurs, but also to bring their products to market. And so I was going to ask Mr. Keating, because you noted in your testimony that the Micro Offerings Safe Harbor Act, which I'm an original co-sponsor of, appropriately scale federal rules and regulatory compliance for small businesses pursuing capital. Mr. Keating, how will this legislation help these startups
that are looking for the investment to hire and to grow and to enter the market?
It all comes down to that cost, and that's why when we talk about scaling federal rules, look at the data, and there's data produced by the SBA and a whole host of other entities, if you will, that show that regulatory costs certainly fall much more heavily on small businesses. Just take us the next step and consider the regulatory costs on startups, and it becomes even more daunting. So when I mentioned before the issue on angel investing, that's certainly in the equation here, in terms of both on the supply and the demand side of the equation. So anytime you can open up avenues here through reduced costs for entrepreneurs to gain access to capital, it's a positive development. And by the way, just to understand that the SEC and certainly the state regulatory bodies have that ability to prosecute fraud, no matter what.
Right, right. Well, here's another question I'm going to ask. I'm an advocate for regulatory relief for our nation's community financial institutions when it comes to their ability to lend. And legislation I've authored, 1188, on the Credit Union Small Business Jobs Creation Act, would free up smaller lenders when it comes to working with startups, business startups. What role do community financial institutions play in capital formation for startups, and what are the problem areas since the financial crisis, and how could Congress help on that front? And I'll go to Mr. Keating and then anyone else who wants to jump in.
Well, my immediate response is those small financial institutions are crucial for small businesses. That's the bottom line. When you look at their share of loans to small businesses, they're critical. So again, the regulatory costs, for example, Dodd-Frank and so on, fall more heavily on them, and small businesses get hurt as a result.
Others on the panel?
Yes, sir. Will, one thing that Chairman Henserling likes to talk about is that every day a community bank goes out of business, and it's not because of bad business, it's because of the burdens, not just overt regulations, but then also the informal, silent regulations of bank examiners who are, basically have a lot of ambit with which to squeeze them and to question the loans that are being made. And as I referenced before, the private sector is trying to come into assistance here by taking off the books of some of the community banks, some of the through funds, some of the loans that they're making, but it's
even on performing loans. That's the great surprise. Performing assets, and suddenly a Cub regulator
because the bank examiner
suggests that just be imploded.
Right. It's a true crisis, and I think we've got to address it. And so I salute you for doing what you can.
Other members of the panel on the subject.
I'll comment that NASDAQ, for the publicly traded community banks, we list over 90% of them on our marketplace, so we have regular dialogue, and I would echo the comments that they are in a very difficult situation right now when it comes to helping small businesses, particularly with all the regulations they're faced, and that group in particular questions the reason why they go public today, and we all know that when they do go public, they do get more capital to support businesses, so I think it is a crisis situation.
The other two panel members on the subject?
At my end of the market, nobody has any assets against which to take out a loan, so it's all equity financing.
Yes, yes. I yield back. Mr. Chairman, thank you very much to the panel.
Thank you. The gentleman yields
Thank you again,
back.
Mr. Chairman.
Thank you. Gentleman, Scott, recognized. Mr. Scott is recognized for 5 minutes.
I had to find the button. Let me ask you about something I've not heard before, and so I want a little bit of clarity of information referencing House Resolution 4855. Could you all explain to me what crowdfunding is? How would the average investor out there, what does that mean?
So crowdfunding in general, it refers to something that's done online where there's broad participation by people in, I'll use some examples, like Kickstarter or Indiegogo or websites where people will fund a social cause or help a company get off the ground by buying their product ahead of time. What we're talking about here for securities law is allowing individuals to, when they do that, not just buy a product or support a cause, but take ownership in the company that they are funding. So it would allow a small company to sell part ownership in it to the crowd. The regulation as it exists in law was set up to put a lot of protections in place to make sure it flows through certain websites and with certain regulations to make sure all the disclosures are happening and it's very transparent.
Yeah, so we're having all kinds of challenges with online lending, online investments. I mean, online payment transaction folks, online merchants. This machine that we've created, the internet, the online services, sometimes appears to me to be like the machine that we created to serve us. We are now having to become servants of that machine. And it puts us in Congress in a way of trying to navigate a situation that is constantly changing with our technology. So the Securities and Exchange Commission has just recently, as I understand it, completed its crowdfunding rules. Is that correct?
Yes, and several months ago. They'll come into effect in May.
In May, next month. Now, to me, I mean, shouldn't we wait until we have some experience from crowdfunding before we make significant changes to the crowdfunding exemption?
So I would answer yes, with the proviso that the kind of so-called online fundraising for accredited investors, the accredited crowdfunding, has been legal since the Jobs Act passed in 2012. There was, I believe, an earlier bill that had more extensive changes to crowdfunding. This bill, to my understanding, is narrowly taking some of the experiences that we have learned over the last 3 years and using that to improve the Crowdfunding Act, in some cases to include investor protections that were not available in the original one. So I actually believe it is a wise thing to do to make sure that some of those make it in place, some of those learnings over the last 3 years make it in place into this crowdfunding version.
And now, there's a grace period involved in this, right? 5-year grace period.
I'm not sure.
Yeah, from my understanding, there's a 5-year grace period during which the Securities and Exchange Commission would be even prohibited from enforcing the crowdfunding rules. Do you feel that's warranted?
That's not my understanding of the law. I don't quite know how to answer that because I don't believe that's the way it's written. I believe what's written into the law is there is a time period during which, when they find violations, they are supposed to give the portals a chance to address those rather than instantly shut it down, depending on the severity of the violation.
Is it not in the bill?
I'm not aware of that portion.
Well, Congressman, I believe
is.
there is a provision in the bill for a grace period, but that's for good faith efforts to comply. So, you know, clearly open to interpretation. But anyway, but I think the intent is to try to encourage the SEC to, you know, to guide rather than to come with a hammer.
Well, it just seems to me that some problems.
The gentleman's time has expired on that one, and I'm sure at the very end we always ask for members of the panel to answer any other additional questions. So at that time, if the gentleman would like to have an additional input from the panel, he can certainly get more into the weeds on the answer on that one. Ms. Wagner is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you all for joining us today as we look at Jobs Act 4 years later and examine the benefits it has brought to small companies and their ability to raise capital and grow their business. As President Obama even said himself, this bill has been a game changer for startups and for small businesses. We've seen this especially in my home district, where recent reports have said that St. Louis has the fastest growing startup scene in the country. This is exciting news, but as many of you have stated today, there is still more work that we can do to build on the success of the Jobs Act and in helping small businesses reach their full potential. So in that vein, Mr. Griggs, you mentioned that, and it has been mentioned before, that in the 4 years since the Jobs Act, that there have been 865 IPOs, with 86% being emerging growth companies. Can you talk a little bit in some specifics here about the most important steps that should be taken to build on that success?
Sure. I think our viewpoint on the most important aspects would be to start considering what it means once you are public and focus on some aspects that we find continually come up with companies about what the challenges are once you do go public, because there's certainly the brand of going public has over the years taken some hits based on what the burdens are, quote-unquote burdens, to be a public company. So I did highlight in my testimony, I think what we feel would be the most important ones would be to provide much more transparency on the proxy firms and what they're requiring companies to do. Companies looking at are continually frustrated by the PCAOB and how they make quote-unquote recommendations to audit firms that they're not really sure how to interpret. And so we do feel that much more clarity needs to be done in that aspect. And then you look at how a company helps or goes about understanding who their investors are. There are rules in place that are requirements to report long positions, but nothing on the short side. And as that has become much more prevalent in terms of how investors use shorts, companies continually ask us to advocate for that. So those three aspects to us would do a lot to help instill more confidence in the public market and going public.
Thank you very much. And my colleague, Mr. Hurt, kind of touched on things. We were all looking at the slowdown at the end of 2015, beginning of 2016, in the IPO period. Now, you talked about market conditions being really the driving force there, but there was still demand. And you touched on it a little bit, but can you talk about some of the regulatory impediments that are perhaps chilling the IPO market?
Yeah, I really would go back to we see a very robust pipeline of companies that would like to go, and typically sometimes you can point to various sectors that have certain regulatory challenges. That's not the case today. So our view is it is much more a market condition than a regulatory condition, because it is across all sectors right now where there just have not been IPOs. But we've seen this in the past, and we do feel very strongly that the second half of 2016 is going to be strong.
Good, let's hope so. I'd like now to turn to the market for private financing for those companies that haven't gone public yet, which is a very important source of funding for startups and early stage businesses. In following up again, my colleague, Mr. McHenry, Mr. Keating, you stated that angel investors' investment is sluggish, and you pointed to regulation and the over-regulatory burden. Can you expand on some of the specifics of that? You mentioned it in a broad, overreaching sense, but what are those impediments, those regulatory impediments that exist regarding this kind of investment?
Well, actually, it is the best way to answer it, it is a broad, overarching issue. I think it's a broad, overarching issue for the entire economy. When Mr. Griggs talks about the IPO market, when we're talking about angel investment, when we're talking about the decline in business loans to small businesses, that's all. There are a whole host of issues in here, but overarching is the state of this economy. You know, a recovery that's growing at 2.1% when we should be growing, if you base it on history, at almost 4.5%. So it all goes back, but then the question becomes, why is that? And I'll go back to, it's pointing policy in the wrong direction in every possible area you can think of in the last several years. especially on regulation. We've been in a hyper-regulatory market on a whole host of fronts, but taxes as well. No leadership on trade. I'll even pick on the Federal Reserve while I'm here, in the sense that they've been saying that they're saving the economy, but in terms of the monetary policy that's been run, it's without precedent. And I've never heard so many small business owners say, what's going to happen with what the Fed's been doing? And they never talked to me about the Fed ever before, because it's uncertainty now. Nobody knows how this is all going to come out. So I would say it is an overarching environment, and then you can go down and drill down into all sorts of individual regulations
Thank
and
you, Mr.
taxes.
Keating. I've run out of time here, and I would say that fourth branch of government, that over-regulatory nature that we have that's been created here, which are the regulators, the agencies, the departments, is not just here in financial services, is overarching in many different areas across our jurisdiction. So I thank you very much. I yield back.
Thank the gentlelady. Yields back. Mr. Hill, recognized for 5 minutes.
Thanks, Mr. Chairman. Thank you for hosting this panel. It's useful, and it's also great to be talking about kind of a positive topic for the economy, because clearly over the past 4 years, this was a bright spot in the Obama administration and congressional collaboration on the economy. So it's nice to be talking about ways to enhance something that's generally working well. Before I ask questions, I'll make a note that recently I introduced a bill that's related to this topic that'll head over to the Ways and Means Committee, H.R. 4831, which will allow people who are using crowdfunding and a Subchapter S company to not have that crowdfunding count as one of the 100 shareholder limitations. Since pass-through ownership's gotten so popular, I'm not sure S-corps are as popular as they once were because of state LLC encouragements. We all recognize that. But in the small community bank arena and in some niches in the economy, Subchapter S is still popular. And so this is a way, I think, to combine the benefits of the Jobs Act with that Subchapter S form of incorporation. Mr. Keating, I want to start with you, and you raised a question that we talk a lot about in here, and that's the AML, the money laundering laws, and you made a reference in your testimony about portals and how they might be treated under AML. Could you elaborate just for a second on that?
Sure. Yeah, we're concerned with applying those to portals. It doesn't make any sense when you think about what, the anti-money laundering laws.
So they are being applied. That it is currently applied to portals.
Yeah, my understanding
prospectively concerned about that.
My understanding is that it's under consideration, that has been kicked around, if you will. And I believe FINRA said no, but now, from what I understand, Treasury it's at least being kicked around there, and we're concerned about that because it's tremendous regulatory cost. There are examples of foreign banks not wanting to deal with American and depositors and so on because of the tremendous regulatory costs. So if you apply that to portals, that would be catastrophic, I think, in many ways.
Thank you. Mr. Beatty, a question for you from a state perspective. Since we've had this experience on general solicitation for a private placement, has it generally been successful that there haven't been noted through the state securities commissioners anything kind of catastrophic happen by having this general solicitation of certain private placements covered by the Act? Has it gone pretty well, in other words?
I think that a relatively small percentage of the Reg D filings that we see are utilizing general solicitation, and in the early history, no, there have not been much by way of reported complaints with regard to them.
Yeah. And Mr. Griggs, you talked in you had two interesting comments in your testimony. One was on the short positions disclosure. Would you elaborate on that for a moment?
Sure. If you look at
explain to the committee why that's important. What's going on out there in the capital markets of people shorting stocks that is concerning right now?
Yeah. So a very large part of being a public company is how you're going to communicate with your investors, and senior management dedicates quite a bit of time to doing that because it does help represent in the capital markets, both for how they're currently stock trades, but also if they want to raise more capital. So today, investors are required at certain levels to report that they are a long holder in the stock, and that dates back to the 1970s. If you look at a short position, companies by no means are saying that shorts are not valuable. They do provide liquidity to the marketplace, and they're an important part of the investment community strategies. But there is no insight to a company about who those investors are that are shorting the stock, the same way there are for long positions. So in the interest of transparency, companies feel to really communicate effectively to their shareholders, knowing who those investors are at certain levels, the same way they know longs, would be very valuable.
Have you seen anything recently in the market that concerns you more particularly, like this IVR patent troll issue and short positions? Are you familiar with that? That seems to strike at the heart of emerging companies.
Yeah, I can't speak to that, but this is not a new issue with not knowing who your short positions are. This has been ongoing for quite some time, but I think as you look at the rise of activist investors, it's really come to fruition in the last several years. It's become much more common conversations we have with our companies.
Thank you, and thanks, Mr. Chairman. My time's expired.
Mr. Emmer is now recognized for 5 minutes.
Thank you, Mr. Chair, and thanks to the panelists for being here today. As we all know, small businesses are vital to our economy. If you define a small business as a firm with fewer than 500 employees, like the Small Business Administration does, then there are more than 28 million small businesses in the United States, and over half of the 120 million American workforce is employed by one of them. Small businesses have also created more than 64% of the net new jobs over the past 15 years, and today, that number is north of 70%. Despite the overwhelmingly positive impact small business has on our economy, traditional bank lending to small business is still at pre-recession lows. Furthermore, if a firm would like to sell stock to raise money, often it must register with the Securities and Exchange Commission. According to the SEC, registration costs $2.5 million on average, which many small businesses simply can't afford. Fortunately, certain security offerings are exempt from SEC registration, including a private offering exemption under Section 4A2 of the Securities Act of 1933. There is a problem, however. The problem is the ability of small businesses to effectively use this exemption is the term private offering is not defined in law. Not only does this prevent small business from using the exemption, it leaves businesses who try to use the exemption and can't afford a team of expensive lawyers, which again, most small businesses cannot, exposed to potential lawsuits and future liability. That's why I introduced the Micro-Lending Safe Harbor Act with 7 of my colleagues. This legislation will create a bright line safe harbor for small private offerings that will help entrepreneurs open new businesses and expand existing ones. It does this by clarifying the safe harbor exemption, not by creating something new, but by clarifying something that exists for any offering that meets one or more of the following criteria. 1, each purchaser has a substantive pre-existing relationship with an owner, or 2, there are no more than 35 purchasers of securities from the issuer that are sold in reliance on the exemption during the 12-month period, or, and this may be the most important, 3, the aggregate amount of all securities sold by the issuers does not exceed $500,000 during the 12 months period preceding. The bill also exempts any of the aforementioned security offerings from blue sky laws while maintaining anti-fraud provisions at the federal and state level. Again, I want to make it clear, all federal and state anti-fraud laws will remain fully applicable to these offerings. On March 27, 2015, former SEC Commissioner Daniel Gallagher gave a speech at the Vanderbilt Law School where he noted, given the substantial changes in technology in the market since this law was enacted, it may be time to see if there are other ways to balance access to capital and investor protection, giving issuers other choices when raising capital. He went on to say, quote, advancing a micro-offering safe harbor which would deem certain extremely small or limited offerings is not involving a public offering under Section 4A2 of the Securities Act worth exploring. As our economy continues to evolve, it's imperative that our laws and regulations also evolve to keep up with new business opportunities and demands. The Micro Offering Safe Harbor Act, which is endorsed by the National Small Business Association and the Small Business and Entrepreneurship Council, is a next-generation vehicle for capital formation. The time has come for Congress to come together and help small business help themselves by making this important update and improvement to the Securities Act of 1933. And in the short time I have left, I wanted to start with Mr. Atkins. It's interesting because I heard that testimony earlier that I believe it's Section 504 of Regulation D already exists, so this would solve this problem. But that would require you to sell up to $1 million in securities in the, I think it's any 12-month period preceding. How would that impact the discussion that we had earlier about the small businesses? I had one in Minnesota, Medtronic. We've got several of them. That Disney Corporation, just name them, Amazon. If you wanted to buy $30,000 or borrow $30,000 from a family member, for instance, how would this impact that?
Yeah, well, I think your bill really helps to clarify what already exists under 506, and I think gives a good amount of certainty. So for that, I think it's a very good effort. And I don't really see huge companies making use of anything like that. It doesn't make sense in the grand scheme of things.
Thank you. I see my time's expired.
Mr. Messer?
Thank you, Chairman. Thank the panel today for being here on this important topic. I want to direct my question to Mr. Atkins to start. And you note in your testimony that there's more work to be done with respect to modernizing the federal regulatory environment. And you also importantly note that federal agencies have issued a record 392 major rules with economic impact of over $100 million annually on the economy. And many of us are supporters of the REINS Act, which would have Congress approve any regulation that had that kind of impact on the broader economy. Could you just talk a little bit about how the regulatory burden impacts small businesses in America in search of capital?
Yeah, well, we talked a little bit before about how community banks are being squeezed, not just by the market in general, but also by formal and informal regulations. So by informal regulations, I mean the great latitude that bank examiners have. Going all the way back to when I was working for Chairman Breeden at the SEC back in the early 90s in the wake of the S&L crisis, you could see how the effect of the bank examiners, what they had on the decrease of commercial and industrial loans and the increase of what banks are holding in Treasury securities. You're seeing a similar thing right now, but even worse, we're seeing community banks going out of business. And so there's a real palpable effect.
Yeah, and you mentioned community banks, but I would ask you a question. Who do you believe receives the most harm or bears the greatest compliance costs of today's current regulatory regime?
Well, effect, it comes down to investors and to Main Street businesses, frankly. Ultimately, they bear the burden just like on any sort of imposition on the economy.
Yeah, the back-end consumer. We're going to turn now a little bit to the Jobs Act, which increased the cumulative Reg A offerings by an issuer from $5 million to $50 million. Again, something this panel would understand well. Despite the significant delays in finalizing the rule, has the new threshold been enough to entice companies to use Reg A offerings? Mr. Keating or Mr. Atkins, if you could.
My quick response is that we've seen positive results with Reg Plus. I noted those in my testimony, but certainly, again, I think that limitation, if you will, leaves money on the table, and why would we want to do that, as I said earlier?
Yeah. What does increasing access to Reg A offerings mean for U.S. businesses looking to raise capital and grow?
Again, I'm sorry.
So what does increasing access to those offerings mean for U.S. business?
Oh my God. This again goes back to the engine of the economy. I mean, when we're talking about, we've heard wonderful things today about small businesses and how vital they are. Well, they've got to get capital to make it all happen, whether it's through debt or equity. So when you're looking at these regulations, they very much have a direct impact on small business and therefore the economy, without a doubt.
Well, and one thing, just to add to my former answer to your question, the main effect of all these regulations and the cost is ultimately on the consumers and the employees of the United States. And in this economy where we have, I mean, to call it a tepid economy or recovery is from 2008 and 9, I think is a real misnomer. It's the, kind of a false recovery. And so in order to try to get people back to work and have consumers enjoy, a better lifestyle, I think we have to make it possible for small businesses, which are the engine of the economy, to get back to work.
Yeah, most new jobs in any recovery come from small business. And so if small businesses can't operate and function in our economy, it's very difficult to create jobs. Folks want jobs. We need to have healthy small businesses, and that requires access to capital, clearly. One last point, maybe Mr. Atkins or Mr. Keating, in the limited time we have. I understand that the SEC is statutorily required to review the Reg A+ threshold every 2 years, meaning that such a review is due this month. What do you think is the most appropriate threshold, and how would increasing it to that amount further aid small business?
Well, I think it'd be interesting to see what the report looks like. But Chair White talked about Reg A+ a little bit at the end of last year, I believe, and talking about how there have been, a lot of an increasing number of registrations under it. But it seemed to me that there's a long way to go. And reading between the lines, I think even the people at the SEC recognize that.
Okay. Thank you very much. Yield back to the chair.
The gentleman yields back, and seeing no other members for a question, I will end where I began by saying thank you to the entire panel for being here, for I think a fairly good discussion on where we're looking to go in this area. Not a position of no regulation, but basically the position of the appropriate level of regulation, not a repeal of everything, but actually just making sure that we have the right level of regulation to ensure what? Investor confidence on the one hand, and at the same time, capital formation on the other hand. So I thank all members of the panel for all their views here today. Chair also notes that some members may have additional questions, as you heard here. So we probably all do. Those questions may be submitted to you within a period of 5 legislative days, as the hearing record will remain open for that time to submit written questions to the witnesses and to place your responses, therefore, on record. And also, without objection, members will have 5 legislative days to submit what do you call extraneous material to the chair for inclusion in the record as well. And so with that said, without objection, this hearing is adjourned. Again, thank you.